All right. So what are we doing here? All right, I'm going to give you a little bit of real background. So Perkins Coie, I'll introduce the law firm for a minute first. I'll give it a plug. So we are a 100-plus-year-old law firm that essentially grew up around technology. The law firm's first client was the Boeing Corporation. And today you would know us. We do a ton of work for Facebook, Meta, Google, Amazon, Intel, Microsoft, literally at the cutting edge of technology and law. I am a startup lawyer. So I started my career 30 years ago on Wall Street in New York, where I worked on billion-dollar M&A deals and IPOs. And do I really want to be in a recording saying that I hated it? Well, sure, I hated it. And I moved out to California 27 years ago, where I started focusing my efforts on working with entrepreneurs, because certainly at the time, Silicon Valley was the headquarters for entrepreneurship, right? And we could, over a glass of wine or something, we could have a long talk about why and how that came to be. But it's an exciting place. And what is wonderful is that that level of excitement and enthusiasm is spread all over the world and in multiple places, Pittsburgh being a great example. You now have thriving centers of innovation and entrepreneurship, lagging a bit on the venture capital side, but whatever, you got to start somewhere. So I'm a startup lawyer. People come to me, they have an idea, they don't know what to do. So I can't replicate what they're doing. I may not even understand fully what they're doing, but I can tell them how to navigate the waters of starting a company, having people own shares, right? Founders owning shares, hiring and firing people, raising money from angels or venture capitalists. We live and breathe that. That is my entire existence. So a couple of years ago, I realized that when I had my conversations with entrepreneurs, they were making statements that indicated to me that they did not necessarily understand what the hell they were talking about. And so I don't know if anybody has heard, like I give a presentation, it's called Valuation and Capitalization. It's not fake news, right? That was my nod to the whole Trump era. Okay, no humor there. All right. And what I try to do is I try to dispel all of these misconceptions that people have about the way things work. And the reason I do that is because I've heard my entrepreneurs say things and I'm thinking, that's just not right. Where are they getting this information, this misinformation, and why don't they understand it? So I put together a series of presentations that sort of start at the absolute basics and build on it. And similarly today, right, we've been doing this for a couple of years, but we're gonna try it a little bit different today. And one of the motivations for me is, we'll talk about this a little bit, chatting with an entrepreneur and saying something about, well, you have to contribute your IP, your intellectual property, to your new company. And this entrepreneur looked at me and said, oh, we don't have any patents. Okay, well, in my mind, like, what does that have to do with anything, right? Patents are merely one form of protection for intellectual property. So what we thought we would do, and I'll let Pete give a real introduction for himself in a second, but when somebody creates an idea and wants to do something with it, I turn to Pete, and we have how many people in your group at our firm? 80?
Yeah, something like that.
Yeah. So we have 1,200 lawyers. We're a large law firm, and we have a renowned technology. Well, Pete's group is TTP, Technology, Transactions, and Privacy. We are world leaders in this. And so I realized that people are talking about their startups and not recognizing a couple of things, not recognizing the intellectual property they have because they don't understand what intellectual property is. They think it's got to be embodied in a patent for it to be IP, and that's wrong. And then they don't really know what to do with it. And so the purpose of a talk like this, we're never going to get through. Pete's never going to get through all his slides. So they're posted online. You can look at it, read it. You have questions, you can email us. We're, especially for lawyers, we're okay guys, right? You can ask us questions. We're happy to answer. We hold office hours regularly. But the idea of this is to acclimate you to these concepts. Why? God forbid you walk out of here thinking you're a lawyer, right? That would be the worst thing in the world on multiple fronts. But the idea is to enable you to say, ooh, I think I have something of value here. What do I do with it? You should talk to a lawyer, right? So I don't come here to push legal services, but you cannot do any of what you're doing starting a company without consulting with lawyers. You will make mistakes, you will screw it up, you will miss value. And the greatest way for you to build your company is to talk to trusted advisors who can guide you. So I'm going to stop talking or else we'll never get into IP. And I'll let Pete introduce himself. All right, a little quick shout out over there. The two people who just walked in, Matt Oshinsky, a partner of ours at the law firm, and his son Caleb, who is taking a tour and interested in ECE. So if anybody here is an ECE person, you can catch up with Caleb afterwards, and I will, all right, see? And I will owe you free whatever you want. Okay. There you go.
All right. Tough act to follow.
Tough act to follow. I'm gonna go get some hot tea while you talk.
Yeah, okay. Yeah, so I think to Matt's point about not understanding what IP is, I think we'll talk about that first, some of the main IP regimes, and then we'll talk about how to, what to do with it. As Matt said, IP is not just patentable subject matter, or you don't have IP just when you have a patent filed with the PTO. You have IP in many different things that you do. Software code, that's IP. That's generally copyright. You don't need to file for any protection over that. It's automatic. You have a slogan that you've been using. If you're using it, that's IP. Now we're going to get into the nuances of like, how do you protect that, and when do you file for that and things like that, but that's IP. Process, you come up with a process to, we have a client I was working with this morning has a process for turning waste plastic into oil. A process, that's IP. Now that's going to be patent generally, but that's already IP. So
is anybody here working on a startup? Do you want to share what you're doing? Actually, I was gonna say, I don't want to put you on the spot. I actually really do, but feel free to decline. But do you want to share what you're doing? And the reason I ask is because I wanted Pete to start off a little bit, just sharing the kinds of things, which is what he's doing, that constitute intellectual property, right?
Yeah.
Do you want to?
So I'm not the founder, but I'm the founding team.
Good.
It's called Orbits Oncology. They specialize in two things. One is organoids. So basically, it's like a mini organ, and you can test hundreds of combination drugs on it.
Which company?
Orbits Oncology.
Okay.
So it's like organs on a chip, are much more scalable. And then the second thing they focus on is image recognition AI to help automate some of the drug development process.
very cool.
Maybe you can just identify some of the things that constitute intellectual property within the reason I asked is we work with Organoid, Ricardo's company. Okay.
Okay.
Yeah, I mean, I'm assuming you guys have a lot of software to do that. That's generally going to be protected by copyright. It sounds like there's patentable subject matter in there as well, some processes, methods, things like that. So yeah, that's in the life sciences space. That's IP is typically front and center, so not as conventional of a concern as sort of a general company that's not in a specific space like that.
But I think the idea is you've created something, right? Somebody woke up one day I don't know if they were working at Nike or not, but somebody woke up one day and came up with some interesting swooshy logo. I don't know about you, but I wish it was me who came up with that little swooshy logo, right? It would be, my name would be on the building here instead of Tepper. But that's intellectual property. And again, the point of this is to sensitize you about those kinds of things so that when you are developing something, hardware, software, a drug, a process, a formula, give me a couple of more. Hardware.
Yeah, a logo, like you're talking about.
A name.
Yeah, a name, a slogan. A book.
A book. There you go. These are all forms of intellectual property for which you can get some protection. And again, I'm going to shut up in a minute and Pete's going to go through a whole bunch of different kinds of IP. And then once you know what this is, we can spend a little bit of time, again, never cover it exhaustively, about how you monetize it, because what's the point of coming up with the Nike swoosh if it just sits in your dorm room or sits in your apartment and nobody ever sees it. The idea is to make money from it. Okay,
That's
I'm
right.
gonna let you talk
Okay.
for a little bit. We'll see how long it takes me to interrupt you.
Cool. Give it about 20 seconds. So I'm thinking we'll just start with IP 101, talk about the various forms of IP. I'm gonna, given the amount of time that Matt spent, I think we're gonna probably have to go a little fast through that, but again, the slides are posted, so no big deal. We'll talk about getting your IP into the company. This is one I want to talk about for a few more minutes, because that's going to be particularly important for those of you who are looking to be founders or who are already founders. And then we'll go into beginning your commercial journey. So sort of the monetization component, what do you got to do? You have this IP, you think it's valuable, what do you do? And then ways to commercialize, sort of building on that concept. All right, so we'll start with copyright. What is copyright? It's a work of authorship, it's original, and it's fixed in a tangible medium of expression. Most relevant to this group probably is going to be software code. Software code is copyright. A computer, drafting code is fixing something in a tangible medium of expression. What works are protected? Literary works, music, pictorial, graphical, sculptural works. Again, most relevant here is literary works. The Copyright Act considers software a literary work. And there are some nuances where that's important that we may or may not get into depending on our time. The interesting thing, I think, to know about copyright, I'm going to go one step farther here. Registration. I think what
does registration mean?
Yeah, okay. So when you register, when you are going to apply for IP protection, that's registered. If you want to register a certain kind of IP, you do that with the government. So you file an application, whether it's trademark application, patent application, or you register a copyright. The Copyright Office handles copyright. The Patent and Trademark Office handles patent and trademark. The interesting thing about copyright is registration is, well, copyright and trademark, but I'll get into trademark. But for purposes of this, copyright registration is not required. So when you're drafting code, for example, the second you're fixing that, the second you're typing it up, drafting it, you have a copyright in that. So I think there's a big misconception that, oh, I have to register my copyright for it to exist. So while you don't have to register it for it to exist, if you want to bring a copyright infringement lawsuit, you do have to register it.
Okay, what is a copyright infringement lawsuit?
Yes.
Let's not use legal terms.
Yep, sorry.
Explain them if we did. Okay.
So if someone, let's say you, let's keep using the code example. You have code that you've written. Let's say your friend or someone copies it. That is copyright infringement. That means, you can sue them in a court of law, and you would get what's typically called an injunction. Well, you would typically get an injunction, which is a court order saying, stop doing that. You might also get some damages, AKA some, you could say, oh, I lost X amount of dollars because they did that. The court might give that to you. But if you want to bring an infringement lawsuit in copyright, you have to register it. So that's kind of the
question.
Yes.
Are there any benefits to copyright protection if you don't do a lawsuit? You know what I mean? Like what's the point of having copyright protection if you can't do a lawsuit?
That's a great question.
Yeah, it is a good question. It's one I've always thought about as well. That was kind of my first question when I first learned this. There are many measures short of full-on litigation that can get someone else to stop doing something. For example, like a cease and desist letter that you can send. It's like a nastygram from a lawyer with header on top that have a big law firm's name and is scary. So that's generally one thing that you can do before actually going to litigation. Litigation is expensive.
Not my area of law, but think about it this way, right? If you have written code and another company starts using it, literally copies it, steals it from you, it's injuring your business. What are you going to do? You are going to attempt to get them to stop, right? You're going to attempt to have them give you money to compensate you for your losses. And having this protection, well, could you term it that it's an easy way to demonstrate your ownership and rights in it? Because you're
a registration.
Yeah.
Well, it's presumptive
Even
evidence of ownership. So generally, when you go to court, getting in the weeds of court, which I wasn't
Yeah.
planning on doing, but I'll make one more statement about it. When you go to court and you're trying to bring an infringement action on someone, generally you have to prove that you actually own the intellectual property that you're trying to assert. If you register a copyright or you register a trademark, that the court will presume that you own it and you don't have to prove that, which is important. All right. Let's talk about, yeah, so there are some exclusive rights of a copyright owner. One of them is copying. So if you have a copyright, you are the only, or if you have a work protected by copyright, you are the only one allowed to copy it, publicly perform it, publicly display it, distribute it, or prepare derivative works. A derivative work, it's sort of an, I wouldn't call it an antiquated concept, but it maps weirdly onto software. But I'll say a derivative work that we can all, that kind of comes to mind is like the Harry Potter movies are a derivative of the book. They take concepts from the book, blow them out into something else, but they're derived from the book.
So that means by having written the book, she controls comics,
That's right.
movies, music, any other thing that is based on those characters.
Right.
She is the copyright owner of that, of Harry Potter, gets to control that. That's the power of owning that. Okay.
Yeah. What's not protected? Ideas, that's generally patent. Titles, short phrases, and you have to have some modicum of creativity in copyright. So it can't just be like a good example is white pages, just sort of a rearrangement of facts is not protectable. And then
is anybody old enough to know what the white pages are?
yeah, that might be.
You don't know. Okay.
I don't think we need to talk about the rest. Okay, so who owns a copyright? It's generally, this is going to be consistent with all of the IP that I talk about today, so we probably won't go through that in terrible detail, but it's going to be the developer, the person who creates it.
So does that mean if I'm a programmer at a company, there are 60 of us sitting in
Good
cubicles,
question.
and Mary over there writes something and Bob over there writes something and I write something. Do we each own the lines of code that we write?
No, thank you for asking.
Thank you.
So typically when you're signing on with an employer, you sign what's called it's called many different things, but it's generally called an invention assignment agreement, which means that anything you do basically within the four walls of that employer's office is actually owned by them. So using his example, what's being coded by all the engineers, the moment it's coded is assigned over to the employer, the ownership of that. So you don't really own anything, even though you would under default law. So that's something to think about if you're, well, both if you're a founder or if you're an employee.
Do we want to take a minute and talk about how IP, or are you going to come to that? You're coming to
Yeah,
that.
why don't we talk, you want to talk about that now? Because we've got a lot of IP to cover.
Okay, well, I'm gonna digress for one moment. So here's my spiel on all the way this works, right? You're all in a lab, you're in school, you're employed, whatever, and you are thinking of things and ideas, and maybe in your spare time, you are creating something. You've got a concept for a company, a product, whatever it is. You may not form a company right then and there. You may wait a day, a week, a month, a year, 2 years, whatever. You've been working on something on the side, you wake up one day. I mean, think about what the pandemic did for people who were thinking about things relating to healthcare, right? It just prompted them to realize the urgency of it. Okay. When you form a company, what is critical is that the people who worked on it, right? Pete and I are working on a startup on the side, by the way, right? When the day comes that we want to do something with it, we're going to create a company. And what we will do is at the moment that we form the company, we will give the company everything that we individually have created that relates to the business. We will cease owning that idea, that code, that hardware, that process, that prototype, whatever it is. And the company will own it, and we will own a piece of the company. The second component of this is after the day of formation, every single person who works at your company, whether it's an employee, a contractor, an advisor, doesn't matter what it is going to sign something called an invention assignment agreement. The way I like to describe this, if you work at Google and you go on vacation and it's 4 a.m. in Hawaii and you come up with a new search algorithm, Google owns it. Why? Because that's what they pay you to do. right? Google's, I know.
They
it's-
probably own it. They probably own it.
Okay, well, we're not going to go there, so
Yeah.
keep going. Okay, but the idea is you put your intellectual property, right? So whatever Pete is talking about that you own because you've created it by virtue of being an employee at a company, you give it to the company. You do not personally own it after you create it because the company gets it. That's the idea of having the company, the integrity of the product and intellectual property.
Yeah, so by default, when you create something that would be protectable by an IP right, so something that's protectable by copyright, patent, trade secret, something like that, by default, you would own that. But again, if you are working for a company or you're starting a company, then that IP is likely going to be assigned, i.e. the ownership is probably going to be assigned from you to the company. So if you are let's say you're wearing your founder hat this time, it's going to be critical that not only do you get your IP, the stuff that you developed into your company, stuff I know is a very formal legal term, but also whenever you're hiring anyone, let's say they're an independent contractor, for example, you're hiring someone to code, but you're not hiring them as a full-time employee. Even if you were hiring them as a full-time employee, you want to make sure that you have an agreement that says, hey, anything that you code or anything that you develop, whatever it is, I own it. It's assigned to the company. And there are magic legal words that you have to get that done. And you wouldn't believe the amount of companies that for lack of a better term, screw that up. Not necessarily fatal, but we have some stories about, for example, there's a company that I was working with that was doing really well. They were about to get acquired, but it turns out some of their key IP had been developed by offshore contractors. No problem, right? Doesn't really matter. When you're going to sell a company or, there's going to be a big investment in the company, that you have what's called a diligence process. People like me and Matt go under the hood of the company and look at all their legal documents to make sure the company has what it needs to have, or what it purports to have. During diligence, turns out that this offshore developer, the documentation was messed up. He didn't correctly assign the IP to the company. Okay, well, normally our process would be let's go find him and get him to sign something that actually does that. Couldn't find him. So, those are common problems. It ended up working out okay, but those are big issues that you might have to face down the road. So it sounds, I don't know if it sounds trivial, but it sounds simple at this point in time, but these problems just sort of metastasize and they become bigger issues when there's actual dollars at stake. So just make sure that everyone you're bringing in to do anything for your company is signing an agreement with adequate language that's assigning IP that they do to your company.
The way I like to do it is everybody here could afford to invest $100 in a company, right? You just could. If I came to you and I said, I've got a company that's cured cancer or can cure cancer, would you give me $100? Or would you give them $100 answers? Of course you would. Would you be surprised if a week later you found out that one of their engineers owned the cure for cancer and the company you invested in didn't own a damn thing? It's going to suck, right? So that's what we're talking about, is ensuring the integrity of a product, the entire chain of ownership and intellectual property, so that people can invest in the company and own a piece of it. Somebody can buy the company in the future, right? A major pharmaceutical company could buy that company that cured cancer for billions, and they would own the cure instead of having some lab, geek in the back come on and say, hey, it's mine. You just bought a company that doesn't own its stuff. All right. Maybe we should go to some of the other forms of IP and then start to touch on the commercialization.
Yeah, that's fine. I just want to touch on one more thing.
Sure.
Particularly applicable. If you're working at a university, you might be a grad student and you're doing research, and you want to spin off a company from that. My first advice is to check with your lawyer. But what you're going to want to think about is what IP policies of the university apply. Most universities, if not, I would say all, have policies with respect to things that are created under their auspices, whether that's using their equipment at their facilities, during normal hours, things like that. So you really want to be careful. obviously it's done all the time, right? Companies are spun out of universities all the time. In fact, they're awesome incubation labs. But you do want to check with your lawyer and check their IP policies to make sure that, everything is kosher on that front. And to put it briefly, most universities will purport to own the things that you're doing under their auspices, and you need to figure out a way to unblock that, and that's where we come in.
Oh, I'm gonna chime in with one more thing. Did you notice Pete said consult your lawyer? Again, I'm not here to sell legal services, but you can't burp without talking to a lawyer today. Just keep that in mind. You must consult. And there are resources here, us, others, right? It's, we don't have an exclusive in the world on being good lawyers, but you must consult with people like me, people with like Pete, as you build your company, or else you will make a fatal mistake.
All right, so should we breeze through IP and then talk about commercialization?
Let's go to the other forms, because I think everybody thinks they know what a patent is, but they don't. So let's talk about it.
Okay. So unlike a copyright, a patent is something that you have to, if you want patent rights, you do have to apply for them and obtain them from the government. Patents, unlike copyrights, they don't necessarily protect ideas, but that's more the general concept. Again, going back to the process I was talking about, converting waste plastic into oil, there's a process by which you do that. That's patentable. That's something that you would file for a patent on. So yeah, what's protected? Processes, machines, composition of matter, biotech, so drugs, things like that. That's patentable subject matter. And you can have different patents based on different uses. So everyone has probably heard of Rogaine, the hair loss thing.
Did you pick that?
No, I didn't. It was originally for hypertension. So there are separate patents on Rogaine for use as a hypertension medicine and for use in hair loss. So
Interesting.
who owns a patent? Same thing. It's the inventor. So whoever comes up with the process, the method, whatever. But again, that overlay of assignment of rights that we were just talking about, it also applies to patents in addition to copyrights. So if you're at an employer or you want to get IP into your own company, you need an agreement for that memorializes that, right? And yeah, you want to make sure that you have those agreements in place with anyone who's doing any work for your company. Patent protection, generally 20 years. One thing that's relevant for startups who might be, a little more strapped for cash is provisional patents. It's a quicker process, it's a cheaper process, and it maintains patent protection for a year while you're still, figuring out whether you want to. Applying for a patent is an expensive process that involves lawyers. It has to, and it's often a decision. It's not just a given, right? It's a decision that it's a business decision to make. So provisional patenting can be one way of, sort of deferring, maintaining the bare bones protection while deferring the bigger decision to later. So we see our clients do that a lot. Filing, another important thing about patent is, unlike copyright where there's not as much of a filing regime, patent filing is critical, and your public disclosure is super critical with respect to patents. So if you think you might have something patentable and you've gone and, like, let's say I'm presenting about my research somewhere and I might want to patent that. Well, the date that I'm doing that, I'm publicizing it. So I have a year from that date to file for patent protection, or I lose it. So
in the case of the organoid on a chip company, so does that mean if he were to come up and present and show the design and show what is unique about what they were able to do? Nobody's ever been able to, I'm making it up, of course, grow organoids on a chip, and you have figured out the temperature and the chemical composition, and boom, you can grow organoids, right? Worthwhile, drug testing, drug development, personalized medicine, all these wonderful applications. If he gets up and says, here it is, here's my white paper, talks about it at the conference, starts the 1-year clock. So on day 366, when you call up your lawyer and say, people love this, I'm going to be a trillionaire, let's file a patent.
your lawyer says you're shit out of luck.
Shit out of luck is a specific legal term, just so you know. I thought I'd get more laughter on that. All right, keep going. Sorry.
Rough crowd.
Um,
And these are going to be things that you say, well, how are they going to know? Well, these are going to be things that come up in the diligence process when you're applying for a patent with the PTO. So I'm not I deal in transactions with patents, but I'm not a patent lawyer who knows how to prosecute a patent. So very lawyer heavy process. If you have super specific questions about that, you'll want to talk to a lawyer to take you through the process. Marking, you need to mark your products with patent marking.
Are you going to talk about what a patent allows you to do and not do?
Yeah, I thought I was.
Yeah, me too. That's why I asked.
Maybe I'm not.
Okay,
Well, I am.
let's swing it.
Yeah.
Go for it.
A patent offers you to sell a product that's covered by the patent. So basically you have the right, there are some nuances to it, but for purposes of this presentation, if you have a patent over something, you can generally sell a product that would be covered by that patent. So I'm going to keep using this example that I have. I'm converting waste plastics to petroleum. I can run that process, sell the end product, but only I can, no one else can. So if someone else is doing that same thing, I can go bring a lawsuit against them for patent infringement and,
Yeah, I think that also not a patent lawyer, clearly, but I think another way to describe this is having a patent over something gives you the ability to prevent others from practicing what is embodied in that patent. So if we have a process, a formula, whatever, and we patent it and somebody else wants to use it, we get to go to court and say, we own the patent. You are not allowed to use it. And Pete's going to get into even briefly the whole idea of how you could allow others to do it and make money, this whole concept of selling or licensing your patented product. But generally speaking, the way I describe it at a corporate level to my clients is the patent doesn't really allow you to do anything. It gives you the right to control the market and to control others' use. And if you think about it, that's a very, very powerful tool, right? If I have patented something, nobody else can touch what I do during that period. Okay.
and not to get too in the legal weeds here, but that's important because if you're bringing a lawsuit for patent infringement, it's what we call strict liability, meaning it doesn't matter if the person who's infringing on it didn't know. That can be a defense to other IP infringement actions, but not in patent. So that's part of the reason why patent protection is so strong, is that you get a 20-year ironclad monopoly. No questions asked, right? So, okay. Trademark. I mean, we were talking about the Nike swoosh. Yes.
So on patent, I have a question about, so since it takes a lot of time to get the patent, and then you can file provisional patent as the first step, what are the benefits or challenges that a provisional patent application entails?
Well, the benefit is that you get to do this sort of band-aid protection where like you're saying, we're as a business, you're assessing whether or not it's going to make sense to go through all the legal fees to patent something, to file a full application, because that involves, depending on how diligent you want to be, that involves like searching prior art and then prosecuting the patent. Those are both very expensive processes. So the benefit of a provisional is really that you don't have to run through those hoops and you can still get protection for that 1 year while you're still figuring it out.
It just allows you to ponder it for a year without a lack of a patent application, right? When the patent issues, which is the term for when the patent office says, hey, congratulations, you have a patent, you get the original date, right? So if you were to file a provisional patent today, Wednesday, you have 1 year in which to make a decision whether to go after what is called the utility patent. That's the real one. It's the one that gives you the decades of this monopoly over it, right? So on day 364, you tell your patent lawyer, let's go for it. You write the larger check and the application goes in, right? that's the protection you have. It gives you that 1 year to think about whether you want to commit. Maybe you're going to pivot, maybe you're going to come up with some other technology that is better, but that it's a cheap placeholder while you decide what to do. Would that be accurate?
Yeah.
Yeah.
I'd say the challenges really goes back to the question of whether you want to patent something in the first place. Keep in mind that patent is public. So I can go on Google. Google has a whole patents database. I can just type in the number, or I can type in what I think the name might be. You can find it, and you can find, all part of the elements of a patent are you have to show the examiner how to practice it, how to do it. So that's all public. So your competitor might, in theory, that could be an issue, right?
How's Coca-Cola doing with their patent on
so,
Coke?
Yeah, so this is the classic example that it's generally patent and trade secret are kind of in tension, right? Trade secret trade secret is it's similar, it's kind of covers similar cases as patent, processes, things like that. But trade secrets are not anything that you would file. There is no filing of a trade secret. Trade secret protection, though, is forever as long as you're meeting the elements of a trade secret, which are incremental value if kept secret, and you're taking reasonable measures to keep it secret, generally through like confidentiality. Problem with a trade secret is, as opposed to a patent, there are statutory rights. People can reverse engineer trade secrets. So people can essentially steal trade secrets, and that's, I shouldn't say that, but it's generally legal. Whereas patent, obviously, as I just said, strict liability, can't infringe a patent, period. But you do make it publicly available, and you get a shorter window. You get 20 years. Whereas trade secret, as Matt said, the Coke formula, that's trade secret. They've never filed any IP protection over that. It is IP, but they've found a way to only disclose portions of it to their, no one, I think, has the entire recipe, right?
And think how foolish it would be for Coke to file a patent, because then people will know exactly what is in the formula. And look at how successful they've been keeping it a secret.
Right? That's why you see, genericized versions of drugs. The patents have expired. So then all the other drug makers rush in and create generics. Yeah.
On the provisional patent application, so if someone decides to not file the full application, will the provisional application still be published?
Yeah, the provisional application would be.
I don't know the answer to that. Since I'm not a patent.
You mean would it remain published after they just dropped it?
Yeah, so I've dropped it. I'm not filing the full application. I'm not writing the full application.
It's a question I've never encountered.
I don't know the answer,
Yeah.
but I can email you.
Yeah.
Give me a week.
Yeah, we have lawyers at the firm who specialize in patent, who prosecute them and such. They would certainly know the answer to that one.
Yeah, let's keep going through it, and let's get to a couple of minutes on how one makes money on this.
Cool. Okay. Trademark, yeah, symbols, things like that. Who owns it? Same deal. Person who comes up with it. Interesting thing about trademark is protection lasts as long as you're using it. So trademark, you can have a trademark forever in theory. And trademark is also, people think of it as being registered IP. It frequently is, but it doesn't have to be. I could come up with a slogan right now and use it in commerce, and I would have rights over that slogan. But the key difference is if I don't register it, my rights are regional, and I can't bring a lawsuit like in federal court for infringement. And there are some other benefits to registering with respect to lawsuits, but generally, clients who are serious about their business tend to apply for trademarks.
And they're not terribly expensive.
Yeah.
Scheme of things.
Yeah. Trade secrets, we just talked about that a little bit, but basically you protect those with NDAs.
What's an NDA, Pete?
Getting into that.
Okay. You guys know what an NDA is? Beautiful. I love it.
Yeah. So anytime, let's say you've got something you think is going to be commercially valuable, right? What are you going to do with it? Or, how are you going to talk to someone about it? Well, you shouldn't just go talk to someone about it, bring your secret sauce out into the world without any documentation or without anything protecting you. That's where NDAs come in, non-disclosure agreement. you will want, before you're talking to any, well, not investor, but any,
Commercial partner.
yeah, any commercial partner, anyone, any other company with whom you're going to do business, or a contractor or something like that, you'll want them to sign an NDA, which basically in one sentence says, I have this information, it's secret, you have to keep it secret, and you can't use it for anything other than evaluating these discussions. And that's critically important, because that, again, not only will it provide you contractual protection, but it also, if you're planning on using trade secrets as a method by which to protect your company, you'll need to be using NDAs, because protection is one element of a trade secret. So once you get past the NDA stage, we're talking like, okay, well, we want to do a deal here. We want you to use our tech. We want you to pay us for it. Well, what are you supposed to do? Typically, a good starting point is what we call like a pilot agreement or an evaluation agreement, which is a scaled down version of like a full commercial agreement. So it's an NDA plus. So it's an NDA plus what I call licensing terms. So with respect to your IP, let's say you have,
Well, can I'm gonna go back a second and just sort of recap and reposition, right? You've come up with a process or a formula or a design or code or something. You've chatted with a competent lawyer and you have copyright protection or a patent or a trademark, or it's a trade secret, right? So you've created something, you've categorized the type of intellectual property it is. I'm like, what'd your parents pay for college for, right? For you to go make money, right? So the question then becomes, what happens in the commercial life of your company and your product? And what Pete's describing is the first contact often with somebody who wants to look and say, what do you have, right? Maybe I want to buy it. Maybe I want to license it. Maybe I want to pay you to use it. I don't know if it works. Would that be fair?
Yeah,
cool.
that would be fair.
Okay.
So let's say, for example, you're approaching a large tech company with, you want them to use your technology. One good way to do this, to get something done pretty quickly, is what's called a pilot agreement, or like an evaluation agreement. These large companies tend to have like big procurement departments with a bunch of lawyers, and things move super slow. This is a way to sometimes bypass that. You pass them an agreement, which is basically an NDA plus very, very basic commercial terms, like some of these terms. Basically talking about, here's my tech, here are your rights to do, here are certain rights to do things with it, here are certain things you can't do, here's what you're going to pay me if anything, and then we're done. That's generally a pilot agreement. And those are things that we typically see young companies doing. Really good way to get started. You can also use like an MOU or an LOI, memorandum of understanding, or letter of intent. That's basically like a pre-commercial deal. See a hand.
Yeah, what type of code we need to like protect it in like other things?
Sorry.
Like we need to like specifically protect your code, or is it just considered IP and like look at
Right. So that goes back to what we were talking about earlier. It kind of depends on what method you're going to pick, but from the get-go, code is copyright. So you don't need to do anything to protect that. Let's assume that you're coding on your own. You're not working for anyone, you're not at school, whatever. You own that, and you have the right to do whatever, you exclusively own it. You have the exclusive rights over it. So, you might make that code available in a repository to this person, to someone who you're trying to do business with, and you would want to have terms for that. You would want to say, here's what you can do with the code. Here's what you can't do with it. At the end of the agreement, you got to destroy it, show me evidence that you've destroyed it, or return it, or what have you, things like that. So that's kind of the basic answer to that. All right, let's see. What is a license? Basically, a license, as we're going to use that term in the remaining 2 minutes that we have, is a contractual right to violate your IP rights, essentially. So it's saying, like, for example, if you're a copyright holder, you have the exclusive right to copy that. So let's say you have a string of code, you have the exclusive right to copy that. You might be granting someone else the right to do that. You're not conveying ownership of it to them, but you're granting them the right to do something.
Do you think anybody here with their laptop or iPads out has a license to something that they're using right now?
Yeah.
What might that be?
Yeah. So
Let's do it.
Microsoft Word or, PowerPoint or whatever.
So,
You don't read the fine print, which I understand. I wouldn't either, but
what do you mean you wouldn't? That's
but I
your
get
job.
paid for it. That's what I was about to say.
That's your job.
That's where they have actually the licensing terms. Like you don't own the technology or the IP behind Microsoft Word. You get the right to use it. Why license? So kind of what we've been talking about, but really, how do you monetize? This is how you monetize it. You don't convey ownership of your IP to another company. You license it. You also get to exercise control. Who can use it? How can they use it? When do I get to terminate you? When do I get to tell you you can't do that anymore? Things like that. So yeah, deviate from background legal principles. So a quirk of copyright law permits reverse engineering of copyrightable subject matter and in trade secret. So you want to generally in your contract say that you can't do that.
Microsoft would not be happy if you sort of figured out all the code and came up with a better product from it. And so they're going to tell you can't do it.
Right.
Right. That's if you want to use the product and pay for it, those are the rules. You don't like the rules, don't do it.
Yep. And then there's some background principles of law like warranties and things like that that you'll want to disclaim. So yeah, it's also to allocate and limit liability. So basically you can enter into an agreement and say, I'm not going to be liable for anything, exceeding the amount of X dollars, and that's enforceable. So you can do that, then if you go to any terms of use, like go to a website and just click on their terms of use at the bottom of the page or at the side of the page or wherever they hide it, you will see a limitation of liability in every single one of them, generally limited to like $50. So those are things that, those are things you have to do by contract. You're not just entitled to that out of midair. So those are things you want to cover when you're licensing. Elements of a license. So yeah,
I don't think
let's just.
you will all have this as a resource.
Yeah.
And you can call us as a resource as well.
Yeah, I mean, you generally want to, again, you want to include restrictions on what the licensee can or cannot do with the technology. These get to be pretty boilerplate, but they're important. You look like
The way I want you to come away from this is, right, we've talked about, you've made something. We've talked about the kinds of things you've made: code, hardware, process, formula, something. We've talked about the categories of IP that it could fall into, right? If you write code, it is copyrightable. If you design some Nike swoosh like logo, it gets a trademark or something, right? That's a label, a category. And this is the start of a discussion about what you can do with it to make money, right? You don't want to create your software and sell it to somebody and then they own it. You have no rights. So you license it. You say to somebody, hey, for $9.99 a month, you can run it on one computer. For $29.99 a month, you can run it on 8 computers. The point being, you now have some familiarity, right? You're never going to say to somebody, well, I have no IP. We haven't filed a patent. That's wrong. There's a crap load of other kinds of IP. You understand basically the kinds of IP: trademark, copyright, patent, trade secret. There must be more, but those are the biggies, right? And you have what I really want you to walk away with is this notion of, I need to call a lawyer because I want to make money on my intellectual property. How do I make sure I own it? How do I make sure I get paid? How do I make sure somebody doesn't steal it from me, do something wrong with it? How do I protect myself if somebody uses it for a different purpose and blows up their business? I don't want them to sue me. And that's why you call a lawyer like Pete, who listens, learns, understands, and then designs the legal contract that gets you your money and protects you. That's the high level basis of what we were doing here.
I think you nailed it.
Yeah, I've done it once or twice. And there's masses of information. Again, the idea, you can look at this, you can read it, it'll make you sound nice and smart when you have any discussion with somebody. But the goal was not to educate you to be a lawyer. The idea was to educate you so that you could have an intelligent conversation with a lawyer or with a potential business partner. When somebody says, hey, just send me the code, I'll let you know what I think. You know, you're not going to do that. You know, you're going to pick up the phone and call somebody like Pete. Okay, we should open it up for questions. You guys better have questions. That's all I can say. We flew 3,000 miles. You got to have questions, please.
So can you patent like a user interface? If it's not like a code, but
Yes. Yeah.
Okay. Surely you intelligent guys in the back must have questions.
There might be people on the line to Zoom.
No, Matt, that was not you. I was referring to these gentlemen one row ahead of you.
So for the example you mentioned, where the company that's greater than that last week, they had that idea. If someone else figures out another way to do the same thing that's separate.
Yep.
Ah, that's a
Can be. It depends. The first one might be what's considered prior art, and it might block the second patent from being fileable. But it might not be. It depends. There are many patents for many things that are very similar, but yeah. So if you independently come up with it, you could still apply for patent protection. Whether or not you get it, little out of my expertise on that requires like a whole, you'd have to talk to a patent lawyer, you'd have to talk about claims, prior art, things like that. But yes, to answer the question, you would be able to at least.
If you can achieve the, again, technically inaccurate, but if you can achieve the same end state, accomplish something, perform a process, and not use the patentable subject matter of the other patent, you have created a different way to do it, right? Right? You would no longer be infringing that, right? So somebody who makes a different, Coke isn't patented, but Pepsi would not be infringing because it's a different formula that tastes similar, right? It's not stealing Coke's intellectual property. For me, this is all the greatest sales pitch of why you need lawyers. And again, that's never my goal, but it is the reality. You could not parse your way through that if you tried.
I mean, patents that are filed get invalidated in court because, they're actually infringing on, there's actually an infringement, right? So not even, sometimes the patent examiner doesn't even make the right call. So it's a field that lawyers dedicate their entire careers to. It's complicated.
So if you're a student and you create a company while not being a student and you're just like using the school's classrooms or whatever, this university has a claim.
Probably. It depends. I mean, again, well, you should call a lawyer, but you should look at the policy. Most universities will publish this on their website somewhere. Most universities have like a Department of Innovation or things like that, where they have their IP policies there. And yeah, you would be surprised. A lot of these policies are very grabby. They purport to own a lot of
But
technology that gets developed.
You mentioned critical words, using the school's resources, right?
Right.
So
that would be the gray area, right? If you were just doing it on your own with your own computer, but you're a student, no problem.
Okay.
Generally.
Well,
But if you're
by being in the building using the Wi-Fi, that's not the level.
It can be. It depends. You got to check the policies. I wouldn't be surprised.
It's CMU students all the time. They all have it.
Yeah.
So you're safe, and work out in the sports center also on their own IP. Unless you're directly invested or you substantial use of CMU resources.
It often ties also to funding. So if something's being federally funded, that's always going to be owned by the university, because otherwise it would be owned by the government. So the university kind of has to exercise that right. But yeah.
I'll give you a great example. I will leave out the graphics chip company name from this, but a client of mine was working at NVIDIA and called me one day and said, hey, got a software startup in real estate. Sounded great. And I learned what compiling code meant that day because he told me that after hours, he compiled his software on NVIDIA's servers. So NVIDIA owned his real estate software. So we made him start from scratch and recode everything on his little Dell computer, not in the office, not on NVIDIA's systems, right? This is why you have to understand these principles, right? Look, many years ago, I'm originally from New York. There was a clothing company that sold, there was a store that sold designer clothing and they took the labels out, but it was all the name brand clothing. And their slogan was, an educated consumer is our best customer. And that's my philosophy on starting a company, right? I want you to be fluent. I want you to know, oh my God, I'm in front of the pothole. I know it's there. I'm not going to step in it. And I get to assess, right? So all of these are just touch points for you to keep in the back of your mind, because they're not black and white answers. They're really gray. I mean, I'll be very careful, but I had a meeting with a client here yesterday, faculty member, and there's a fascinating question about what this professor does in his lab versus what happens at the company. I cannot answer his question. It is way beyond my knowledge, that fine line between whether what he does is owned by the company or the university. So these are all things where it is great to understand, I'm in a danger area. I'm going to go do a consultation with somebody knowledgeable.
Yeah, and again, not trying to plug us necessarily, but it's really just spotting the issue. It's just seeing, oh, this might be a problem for me, and then you go talk to someone who can handle it.
Right.
We're not, you wouldn't be expected to put together your own agreement containing all this kind of stuff.
Don't do that.
Yeah, I would in fact recommend against it, but it's just to know, like, oh, I'm about to go into a meeting with someone. They want to know more about my business. I should probably get an NDA.
What happened to the NVIDIA program after?
What happened to
So
his original?
Yeah,
He just abandoned it. Absolutely abandoned
so
it.
it was still owned by NVIDIA.
There is no doubt in my mind that NVIDIA had absolutely no clue about it. There is no doubt in my mind that NVIDIA could have cared less about it. That's not their business. But nobody would give him money, because at the end of the day, let's say his software was worth $1 trillion. NVIDIA was going to wake up and say, that's ours.
So he couldn't own ownership to it after.
He could, well, NVIDIA owned it because he did it on he used their resources. End of the story. It was easier and cheaper for him to just start from scratch. He did not like me that week, but I saved him.
How similar to like two pieces of software to be considered like copy?
It's a good question. I figured we were getting there. So this is, again, a little bit out of our depth because I'm not in litigation, but I will tell you that generally it has to be substantially similar, so that, and that's kind of a legal word, but it's basically like, do I look at two things and would I draw the inference that someone copied? It's kind of, that's like what it boils down to. Because independent development is a defense to copyright infringement. If I if he took that code and completely redeveloped it without referencing or using that prior code at all, then he would win theoretically, depending on how good his lawyer is, he would win in court. That's there's no copyright infringement there. So it's really a fact test, and it's just like, looking at two things. Is there any possibility that this was done independently?
So what were the two legal phrases we've learned today? What was the one you just used? Independent development and shit out of luck. I think those were the two legal phrases.
I've used stuff quite a few times today. I have a
third legal
bad
phrase.
habit in doing that.
Are we done? Oh, yes, bring it on.
Yeah.
So in the earlier example where the IP creator gave a public presentation and that they thereby were shit out of luck, would filing a provisional patent allow this type of public disclosure for 1 year without loss of protection?
Yes.
That's the clearest answer we've heard today.
Yeah.
One word from a lawyer. That's worth $1 million. Anything else? Okay. Well, thank you all for coming.